Okay, so we come to the last topic. Topic 12. What is patent infringement claim? So essentially, I go and contest somebody else's idea, then I'm claiming that my patent has been infringed upon. It has been copied. My idea has been copied. Now, this idea could be copied in full or in part. It doesn't matter, but I can always go and contest, right? And it happens mainly for technology companies where like any product will work in with a combination of innovations. So you go and claim that one part of innovation is copy of my idea. So you can always have patent infringement claim before the patent is granted or after patent is granted. So before patent is granted, at any given time after the details are published by the patent authorities, you can go and always claim that this patent should not be granted. So this is before the application has been approved. That is easier, but in that case, the large companies have dedicated team which will always do this task. It's not for individuals who will be able to kind of keep track of such large databases. Second is to contest the patent after it has been granted, and it has to be contested within 1 year of granting the patent. So you can claim oppose it prior to patent being granted or after patent is granted. And then what are the grounds on which you can go ahead and put a opposing claim? So number one is definitely not a new idea. You can always say that this idea always existed, and you point out to that incidences. Second is it is not so obvious. So that is somewhere, like it could be a very detailed examination which can happen, and you can always try to point out that it is not a obvious step. And third thing which companies increasingly are using is they are pointing to the procedural lapses, that the company who has filed for a patent has not submitted all the details, and hence the patent should be rejected. Sometimes there will be a groups who are representing a community, so they may get involved and they may contest patent right, saying that this is against the community right, or it is against the morals of society. Like for example, any right in any patent being granted in medical field can become a contested idea because of the impact which will have on the society. So let us go through some refresh the topic and go through major points. So patent infringement means violation of patent owner rights using innovation or part of it without permission. So patent application can be contested before the grant of patent or after the grant of patent. And the grounds for patent opposition can be patent infringement. There is no novelty, there are no innovative steps, and the procedures are not followed. So if patent office rejects this claim, then always there is an option of litigation, which could be a long drawn or costly affair. So let us look at some case laws. I have included this after this topics. The reason is this case laws decide the way uh, the future things are shaped. So I'll just take three case studies in the next uh, lecture and next video, and then let us see that how it impacts the entire patent decision making process.